Now, my presentation this afternoon is about Justice Madan's jurisprudence on the law of arbitration and the law of marriage. I am hoping to convince you that after you hear my presentation, you will be convinced that law schools should teach the law of arbitration and the law of families with respect to dissolution of marriage and custody of children should be taught differently. I have already published an article in Chartered Institute of Arbitrators journal about arbitrability, marriage nullification, and custody of children in Kenya. That article is available online, so you can access it. My conclusions in that paper are several. I will not go into them. I will just read them quickly. One, party autonomy means power to the people. The people should decide which forum to take their disputes to. That right is inherent in the Constitution, but it's also related to the freedom of and from religion. Justice Madan decided several cases on arbitration, but I'll go straight to the third one, Nurani versus Nurani. This is simply the leading authority in terms of whether marital disputes related to nullification of marriage or custody of children can be arbitrated. The case is about the jurisdiction of Ismailia Muslims in-house tribunal in this regard. And in that decision, Madan answers or responds to 6 of the objections which have been raised against the possibility of arbitrators hearing such disputes. One is that the High Court has exclusive jurisdiction on nullification of marriage and custody of children. That is the first objection. And his response in that decision is, where a party has already submitted to the jurisdiction of the council, it is impossible for the same proceedings to be instituted in the High Court. Objection number 2, religious tribunals lack police or enforcement powers. And the response is in that judgment, Nurani versus Nurani. Madan says, a disciplinary action ordered by a sectarian tribunal carries the immense might of moral sanctions imposed by the society through its power to order ostracism, excommunication, economic boycott, etc. So he says basically, the society has a different kind of police force, not the police force you are used to, and it can impose sanctions to enforce its decisions. Objection number 3, that laymen and women lack understanding in matters law. And Madan has not commented on that particular angle, but his colleague on the bench in that particular case was Justice Law. And Justice Law said, as far as the welfare of the children of the marriage is concerned, I see no reason at this stage to think that the council will not properly discharge its duty. Objection number 4 is that arbitration is for commercial disputes only. I'll not, maybe I should read what Madan said. I am not aware of any statutory provision which prohibits a set within the general society from setting up their own tribunal for the settlement of matrimonial disputes between its members. Objection number 5 is that the Children's Court has exclusive jurisdiction on custody of children. Madan answers as follows. It is incorrect statement of law that the High Court has exclusive jurisdiction under the Guardianship of Infants Act. It is incorrect to argue that the Council cannot apply the guardianship of the Infants Act. The 6th and last objection is violation of public policy. And Madan repeats, I am not aware of any statutory provision which prohibits a set within the General Society from setting up its own tribunal, etc., etc. Was Madan aware that he was creating a landmark case when he wrote his judgment in Nurani versus Nurani? He provides 2 clues in that decision. He says, it is the first time that the issues ventilated here have been considered and decided by the Court of Appeal. Perhaps a service has been rendered to jurisprudence in Kenya. Then, when considering costs in Nurani versus Nurani, he says, perhaps a service has been rendered to jurisprudence in Kenya. Madan was definitely aware that he was setting a landmark case on this matter in Kenya. The next point, which I have pondered as I have looked at several cases decided by Madan, is, was Madan averse to case law? In Nurani versus Nurani, he has not cited a single authority, even though he admits that this matter has not been ventilated in this court previously. 0 authority. He simply uses common sense and logic. Now, in East Africa Power and Lighting Company versus Kilimanjaro, he cites 1 authority. In Esmailij versus Mystery, 1 authority. And in Gadigia versus Rushadi, 1 authority. Now, even in those 3 cases where he has cited 1 authority in each case, he merely cites the authority. He does not quote even a word from the authority, which I have found a little odd. Now, had Madan foreseen Article 159 2C of the Constitution? I have pondered that because he has decided his cases exactly as prescribed in the Constitution of Kenya 2010, which came decades after he made those decisions. So the answer is no. Why? Because he did not claim to have supernatural powers. So why pose the question at all? And it's because of the reason I have given above, that it's like he really complied with that provision. I'll now go to the last slide. And the context is that Christians and Christian denominations have not asserted their rights to determine issues related to marriage and custody of children outside court. The Roman Catholic Church has a very thorough canonical code on marriage and children. And I think it should pave the way, lead the way, as it did in another matter recently, in asserting the rights of the Christians to arbitrate their members' family disputes. Thank you very much.